1. Kinds of jurisdiction under international law. Prescriptive jurisdiction. This is the authority of a country to create laws that apply to people, actions, or situations within its boundaries. For instance, a country can prescribe laws on taxation or environmental protection. However, international law limits this when it conflicts with the interests of another country. Jurisdiction to adjudicate refers to the power of a country to bring individuals or entities before its courts, whether for criminal or civil cases. This requires a significant connection between the country and the matter at hand. For example, a country can prosecute foreign nationals for crimes committed within its borders. Jurisdiction to enforce. This is the power to enforce laws and ensure compliance through penalties or sanctions. For example, police actions or fines imposed must have legal backing. This jurisdiction often requires permission when enforcement crosses into another country's territory. Question 2. 5 offenses under the Cybercrime Act. Cyberstalking, using electronic communications to repeatedly harass, threaten, or intimidate someone. Punishable under Section 24 of the Act. Cybersquatting, registering domain names identical or similar to trademarks with the intent to profit. It is prohibited under Section 25. Racist or xenophobic offenses, spreading hate speech or content targeting specific races, ethnicities, or religions. Governed by Section 26. Identity theft and impersonation, stealing another person's identity for fraudulent purposes, punishable under Section 22. Cyber terrorism, using digital tools or platforms to threaten national security, infrastructure, or safety. Carries the severest penalty under Section 18. Each of these offenses highlights a specific type of misuse of cyberspace and seeks to protect individuals and national interests from harm. Question 3. Elements of defamation. Defamatory statement. The statement must damage the reputation of the plaintiff, for example, accusing them of a crime or dishonesty. This can be direct or implied, innuendo. Reference to plaintiff. The plaintiff must prove that the statement was directed at them specifically. If it is a general statement about a group, an individual can only claim defamation if they can show the statement applied to them. Publication. The statement must be communicated to a third party, as defamation is not actionable if it is only known to the defamed person. Defamation protects individuals from false statements that harm their reputation, but all 3 elements must be present for a claim to succeed. Question 4. Defenses to defamatory actions. Consent. If the plaintiff agreed to the publication, the defendant cannot be held liable. Unintended defamation. If the publisher didn't know the statement was defamatory and took reasonable care, they may not be liable. Justification. The defendant can defend themselves by proving that the statement is true. Truth is an absolute defense in defamation cases. Fair comment. Honest opinions on matters of public interest are protected as long as they are not malicious. These defenses ensure that freedom of expression is protected while balancing the right to reputation. Question 5. Theories of intellectual property. Economic theory. Protecting creators ensures they can recover their investments and encourages more innovation and creativity. Natural rights theory. Intellectual works are the result of personal labor, and creators have a natural right to control and benefit from their creations. Reward incentive theory. Intellectual property laws reward creators by granting exclusive rights, which incentivizes further innovation. Development theory. Intellectual property protection promotes social, cultural, and technological growth, benefiting society. These theories provide the philosophical justification for intellectual property laws and their role in encouraging creativity and development. Question 6. Difference between real space and cyberspace. Real space. Physical transactions inherently carry identity information, e.g., physical traits, voice, location. For example, buying something in a physical store automatically reveals some personal details. Cyberspace, transactions are digital, represented as binary code, ones and zeros, and do not include personal information unless added separately. This anonymity makes cyberspace prone to issues like identity theft and fraud, requiring verification systems. Understanding these differences is critical for addressing legal and security challenges in cyberspace. Question 7. Test for freedom of information exemption. Engagement test determines if the information falls under protected categories like national security or legal privilege. Injury test assesses whether disclosure would harm sensitive interests, such as endangering public safety or breaching privacy. Public interest test balances societal benefits of disclosure against potential harm. For example, releasing information that exposes corruption might outweigh concerns about confidentiality. These tests ensure a fair and balanced approach to granting or denying access under the FOIA. Question 8. Rights to information under FOIA. Right to request information from public bodies or private entities using public funds. Right to be informed about the existence of specific records. Right to receive requested information unless exempted by law. Right to access without demonstrating specific interest in the information. Right to challenge refusals in court. These rights promote transparency, accountability, and public participation in governance. Question 9. Explanations of terms. Cyberstalking, persistent and unwanted electronic communication intended to harass or intimidate, such as threatening emails or social media messages. Cybersquatting, registering domain names similar to well-known brands to exploit them for profit or mislead users. Racist or xenophobic offenses, using the internet to spread hate speech or incite discrimination against specific groups based on race or ethnicity. These actions are regulated to maintain safety and respect in online environments. Question 10. Difference between computer crime and cybercrime. Computer crime involves traditional criminal activities like theft or fraud that use computer systems but may not rely on networks. For example, stealing a laptop with sensitive data. Cybercrime, committed entirely in virtual space and often crosses borders. Examples include phishing attacks or ransomware. The distinction lies in the involvement of physical systems versus virtual, networked environments. Question 11. Cyberspace vs. real space. Cyberspace, a virtual, borderless realm where interactions occur through digital platforms. Identity and location are not automatically disclosed. Real space, physical and tied to geography, where identity and location are inherently part of interactions. Understanding this distinction helps address legal and social issues unique to cyberspace. Question 12. Concepts of cyberspace and cyber jurisdiction. Cyberspace, a global network that facilitates interaction and communication without geographical boundaries. It evolved from text-based systems to a vast transnational network. Cyber jurisdiction, the legal authority over activities in cyberspace, often involving multiple countries. For instance, an online transaction may involve users, servers, and businesses in different nations, making jurisdiction complex. Addressing these concepts requires international cooperation and clear legal frameworks to resolve disputes.